Stand, please. Oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 20-3084, United States of America versus Frederick A. Miller, also known as Toby, appellant. Mr. Hart for the appellant, Ms. Hart for the appellate.
Mr. Clark, before we begin, let me just put on the record, on behalf of this entire panel, how delighted we are to be back for share that with all of you. I'm sure we're delighted to come. So if you'd like to proceed.
Thank you. May I please report, my name is Dennis Hart. I'm here this morning on behalf of Frederick Miller, again, North of the before this court, this court. The narrow issue that is important one is I'd like to begin our presentation with a question about mandate. Maybe the first question the court has to face, and perhaps the last question the court has to face. And that question is the application of the language of grant in the mandate rule to the facts of this case. With the fortunate presence of computer research, I was able to count the number of times we were vacated period in the 2018 opinion by this court. It appeared 17 times in the opinion.
What was the word?
Vacate.
Oh, wait.
Or the reverse appeared only 3 times. But when you're able to search that way, you can go to each vacate in your opinion and see what it refers to. At no time in the 2018 opinion did the panel in this court take his conviction for the failure of the government and the district court to satisfy the enhancement that were the 2 enhancements that were received. Vacate and reverse are sometimes two different actions of it. We suggested in our brief that that may be a test for whether it meets the remedy. For vacate means the court can consider everything. Reverse means it has to go a step back to remedy the problem this court saw in the sentence. We have a second test that we'll get to a little bit later because we just got a number of vacate cases also. Secondly, we believe the government asserts that the sentencing meter in Mr. Miller's case goes back to zero after the 2018 return. We don't believe it does. We believe under red it goes back to two steps.
Under what?
Under red.
What?
Red language, I think it's very restricted significantly to sort out in the town. But it applies to the government as well. We believe the district court should only go back to two steps for the enhancement, not back to zero, not start at zero at the ground floor. If the court agrees with the appellant, then the district court erred in its sentencing in 2020.
Mr. Hart, the argument is that the enhancements, if the enhancements are invalid, then the sentencing on the RICO count, which previously the enhancements was like, this enhancement proves supportable, that makes newly relevant an argument for a variance. So why is the vacature of the RICO count and the decision that the enhancement couldn't be supported enough under this particular remand and all its limitations, nonetheless consistent with what the district court did on it?
Well, I would disagree with the word newly and relevant. Let me explain why I disagree with the word newly. This is not new information. This is information from the 2006 and 2007 trials. So everyone knows it's not relevant because the mandate from this court was essentially fulfill your obligations for the weapons enhancement and for management. It was a cross the T's and dot the I's directed by this court. Everyone thought the district court could do that. There really was no serious doubt that they couldn't do it. Well, I can't speak for the government. We thought it was just not a victory for the in Miller 2018, but rather a roadmap for the court to do it correct the next time. That certainly was the view of the government last year. Almost a year before Mr. Miller was sentenced, the government maintained that it had enough evidence to support the weapons enhancement, the managerial. It did through, I believe there were 4 assistants on the case. They submitted several sentencing memorandums. The first 2, quite lengthy, all argued that there was sufficient evidence to support weapons and management. Gave the opportunity for the court to adopt that. The court did not adopt that because the last sentencing memo for the government agreed that they could not meet their burden of proof. Thus, it's not newly, it's not relevant because this court directed the district court to cross the T's. It could not cross the T's, and that was failure of proof by the government, rather than directed by this court. I want to address one of the cases the government cited in this 28-J letter. I think his name is Henderson. And that Harrison, it's just in the 28-J letter submitted by the government earlier this week. It's a drug trial in which a year offender enhancement was vacated by the court, I believe it was the 4th Circuit. They concluded that when he was resentenced and given a life sentence under a variance, that they could do that and did not violate the 4th Circuit mandate because the government was not given the opportunity for the 4th Circuit to argue for this variance in the first sentencing of Mr. Shutt. That's a very good illustration of what happened here. Remember that the appellant was sentenced in 2007 to life in prison, mandatory life in prison. The government had no chance to argue that in 2007. But he was resentenced after remand by this court in 2016 to RICO life in prison. RICO does not carry the mandatory life in prison that the CCE county did. And as a result, that was the first opportunity for the government to argue there's a possibility for variances for whatever reason. They did not. Since 2016, the government has always maintained that this is a guidelines case. There is no variance until the last minute before sentencing. And that they argued there were sufficient facts under the guidelines to meet the burden for life in prison under the guidelines.
So, Mr. Hart, is your position that the government, even if it might be duplicative of its principal ground, here, the enhancements, that the government has to, in order to preserve them, make all potential arguments for enhancement and or variance at the first opportunity? In other words, in this case, in 2016, where it was looking for a basis to go to the higher sentence, that unless the government rolls out every argument at that point, those arguments are effectively.
No, I think they have to bring out their best case. And their view was their best case was the guideline sentence in 2016. They maintained that throughout 2019 before the district court judge, and then finally agreed that they couldn't make the case. They made that bet. They have to lose.
So they make their best case. If their best case fails, I think that is what I was asking, although the answer is no. If their best case fails, if they want a fallback, they need to have articulated that in 2016.
They do. Otherwise they wait. Because they had that opportunity and chose not to pursue. Beg the court to excuse my strainer, talk to the mask, and it doesn't come out the same way it does in person.
And I think the answer is that there isn't any precedent directly on that, either from this court or any other court. Your closest case that best supports that position is what?
Well, I'm saying the Chuck case that I just mentioned is an example of that, where the court said no, the government didn't have a chance to argue that because it was a mandatory. If they hadn't, it implies that if they had that chance, then they would have violated the mandate if the court gave it second time around. I see that I'm kind of up. We'll give you a couple minutes and we talk. Thank you.
Before you sit down, let me just ask you, talk about life without parole, but my understanding is there's no parole in the federal system anymore. Can you clarify what you're referring to?
Life without parole is an easy way to abbreviate that. Prisoners are given certain benefits, such as good time. They can credit for good time. You can be released early based on good time. Prisoners are sentenced to supervised release, which many people view the same thing as different content. So without an end term, that has significant effects on the person. Thank you. Let's start.
Supreme Court, and Park on behalf of the United States. District Court here did not violate this court's mandate in order to by imposing upward variance and resentencing conflict with this. Under Wren, when remand and resentencing, District Court may consider only such new arguments as are made newly relevant to the Court of Appeals decision by reasoning or by result. Here, Miller 2 mandate refers to the mandate for resentencing firearms enhancement, the leader or organizer enhancement, and the legal conspiracy enhancement. Based on Miller 2 opinion, the prosecutor did not seek the enhancement because the court did not apply it. The result of this court's decision in Miller 2 was a lower guidelines range where the upper end was no longer life imprisonment, which made the government's request for an upward variance of 2020 resentencing newly relevant. The Government had no reason to ask for an upward variance, either at the original 2007 sentencing or the statutory mandatory minimum for CCE with life, nor did it have a reason or incentive to ask for a upward variance at the initial 2016 resentencing, but the district court had determined the actual guidelines range for the conspiracy was 360 months of life in prison. The district court could therefore consider the government's argument for an upward variance.
We don't have a case supporting that position, do we? Which in this new law to find, contrary to your opponent's argument, that you don't have an obligation to make your alternative best case in the first time that you need to make up the gap.
When talked about reason and other courts in talk about
Could you speak a little louder?
Oh, I'm sorry, Your Honor.
Is there a microphone
There is a microphone. I'm not
there?
sure.
Raise the-
Raise the table. I apologize. I will try to speak.
It makes all the difference in the world.
I'm sorry?
It makes all the difference in the world.
You can hear me?
Yes.
Thank goodness I don't have a mask to make it work. But Ren talks about reason or incentive. And what appellant seems to be saying is we have to make all our arguments, all our alternative arguments at the beginning, initial sentencing, or else we're going to lose and fall. That's simply not what Ren says. And here, after 2016 sentencing, after the district court calculated the guidelines range, he turned to the parties and said, any arguments that counsel would like to make about whether the court should depart from the guidelines under the 3553 factors, I'll hear. And that's on page 12 of 2016 transcript. Clearly, at that point, the government had no incentive to ask for an upward variance under the 3553 factors, and the upper end of the guidelines range was life. It would make it awkward to ask the court at that point, well, in case this gets reversed on appeal, these enhancements can reverse on appeal, we would ask you to make an alternative finding for an upward variance.
But Ms. Park, the part of the transcript that you cite actually seems to cut the other way, because the district judge himself was contemplating that notwithstanding that the upper bound of the guideline sentence with the enhancements was life, you might nonetheless want to make variance arguments, and didn't. The government didn't make variance arguments at that point.
Yes, I think when he's practically speaking, I think that was really addressed to appellants at that point. And when he says the court, I think he means variance because he's addressing the 3553 factors, just in scope. But
I think that was correct.
yes. So I would suggest to the court that to ask the government to make the argument, alternative arguments, upwardly depart from life, they're upwardly vary from life. There's really no such thing, and that's basically the end of that.
I see the logic of your position. But we're all lawyers, and we all know that the primary grounds on which we start defendants that we want might in fact be vulnerable. And where it is in the judgment of the government that the enhancements, for example, might be unsupported, why wouldn't it make sense to say that the government needs to make its best judgment, do belt and suspenders, as lawyers often do, and go forward with that assurance? What are the available grounds to make up the gap?
The difficulty is, at what point do you say it was shaky enough that you should have made an objection? It seems like you're asking the court to go back and look to see whether the opportunity had risen to a certain point where the government should have done it. It seems to be saying he objected to these enhancements. So because he objected, the government at that point should have known this might be reversed on appeal and made their request for upward variance then. I think it's hard. I think the Ren standard is really workable. It's no reason or no incentive. It's a practical
The difficulty is this sort of infinite regrets, the second bite of the apple, the third bite of the apple, that, the district court tries one thing, the government has no incentive to make sure that it's confident in the various grounds that it proposes for variance and or enhancements, because it knows always if there's a shortfall and bring something else up and then bring something else up. And here I understand it was the court that brought up the ultimate basis for the upward variance, more so than the government. But the difficulty from the defendant's perspective is it's an infinite moving target, infinite bites at the apple to get the sentence right. And that may be, that's plausible system. The question is, it's the system that we have.
Certainly not something that this was adopted. I mean, I think what your honor is talking about is a no approach when you have a resentencing, anything, you can add any arguments or make any arguments for that any evidence we could have at the original sentencing. And some jurisdictions have adopted that. Purpose when this court adopted Wren was the reason was to limit this kind of you always get first bite, second bite, third bite. You can only deal with issues that arise from the correction of the sentence resulting from court of appeals decision. That's essentially the heart of the Wren, and they rely on the Seventh Circuit case when they talk about adopting this waiver approach versus no approach. And that seems to me to strike a fair middle ground, because it doesn't seem fair to allow litigants to have to make every single alternative argument at the original sentence, even if other parties may object to enhancement. But it does say if you have a strong reason to make it right then and there, you should have. In this situation, where the upper end of the guidelines was light, the government simply had no reason or incentive to ask for a variance going upward on alternative basis.
Let me ask you about the district judge's reliance on the Oguchi murder attempt. It's troubling that occurred, at least appears to have occurred. We don't want findings to the contrary, that it appears to have occurred before Mr. Miller joined the conspiracy. How is it permissible for the district court to take into account conduct that is both quite notable, hard to see as just marginal harmless, that was engaged in before Miller was involved, and we're not even sure what the law is.
Yes, Your Honor. And I would say, well, the district court here, this is not a case where the district court was trying to make, incorporate that conduct into the guidelines calculation, where he would have to find relevant conduct and particular sign. Here, he was doing a more broad assessment of the evidence, and under the 3553 factors. And this court has said in Ransom, the court is not required to make findings in the guidelines imposed on the variance, and it could properly apply broader 3553A considerations in assessing the evidence and determining when an upward variance is warranted. So that's what the district court was doing here. And when you look at the language of the statement of reasons, and I believe it's pretty much verbatim in the transcript, when he talks about Uruchi, he says people like Mr. Uruchi were previously injured as a result of the conspiracy that he killed. So it's an example.
Do we have there were other similar acts that the Uruchi attempted murder could have been a shorthand for that occurred during the time?
I don't know if the shorthand for it. I know there were other murders.
For example,
other murders, they did not, district court did not rely on them.
but I thought the argument you were making was that he referred to the Uruchi attempted murder as a signifier of a kind of harm that this conspiracy visited on the public or participants or what have you. But then you seem to be saying, no, that's not your point.
No, that is my point. I mean, he was taking a broader view of the evidence. It didn't really matter that how it was involved in the Uruchi murder. It was the fact that this is the nature of the conspiracy. He joined, we don't know at what point, he joined and he led And the origin murder just kind of underscored the type of actions that this conspiracy did and was capable of. And,
So are you saying there isn't another attempted murder or murder or violent assault incident that you would point to after when we know Mr. Miller was involved of which the Alucci assault attempted murder would be an example, just one example. That's not.
Your Honor, there are other murders, at least one other murder that I know was charged and there was evidence upon it. I do not know off the top of my head the time frame of when this murder occurred.
That was what through
That Pruitt, I think that means.
it? Okay, that was 2001, and that was an island, was charged with being an accessory after the fact, and he was acquitted on one.
The point here I'm just trying to make is the court was looking at the Alucci murder, the other conduct that Pelham did not himself do. The incident with Bradford, that was intimately, where he misused his private investigator, that was all him, and I don't think it's directed. I think the point the court was trying to make was, he's looking at the nature of the defense and overall harm caused by the conspiracy. And, in light of the attempted murder of Alucci, Pelham's offer to kill Valentino Palmer on behalf of Bradford was not an isolated incident in the conspiracy.
Do we have record evidence that Mr. Miller was even aware of the Alucci murder attempt?
I believe there is. I don't believe there is. He was.
So it wouldn't bear at all on what was Mr. Miller's intention, whether he was just trying to butter up Mr. Bradford and talk tough, or whether he was the kind of person that might have actually followed through, which I thought was what you were suggesting.
Yes, but I'm looking at the murder in a broader sense. And not so much that he knew that it happened, but just that this is an example. Island was very involved in the Alucci murder for sure. And Island was actually outside outside the parking lot when Pelham went in to see Bradford, and actually Bradford wanted to talk to Island. So he's very much involved in what's going on with Bradford too. I think the point is, this is the kind of conspiracy Island and Pelham were running, and we know what they did, and what they did was murder people who stood in the way of their goals. And there was nothing that the threat that he made, offer to kill Valentino Palmer, was very real. And certainly, it's reasonable to infer that Jay Bradford thought it was real, because he immediately started backtracking when the
And I'm not really questioning that interaction on its own. It's really the district court relies on the Alucci murder attempt. If we were to think it was impermissible for the district court to rely on that Alucci murder attempt because it A, predated Miller's involvement, and B, there's no evidence that he was aware of it. What then?
I think the court was looking at all these factors, and see the use of the private investigator credential. That was certainly atypical, and that was an incident that was repeated by the prosecutor at the 2007 sentencing, 2016 sentencing. It was a consistent theme.
Right. There are other factors.
Yes.
But what's legally available to us? We don't know whether the district court was even aware, because the district court on its own came up with these regimens. The government hadn't briefed it. Mr. Hart hadn't responded to it. And he came up with, we don't even know if the district court was aware that this murder had happened perhaps many months or a year or more before Mr. Miller was involved. Maybe it was central to his consideration, and he would never have meant to rely on that if he knew that there was no nexus to Mr. Miller. What do we do? Can we say, oh, harmless error and just affirm?
Well, the mandate, we are now talking about procedural reasons.
What was that last one?
I think we moved on to the reasonableness of the sentence not the mandate. I was going to say the mandate issue is plain error. Didn't ever oppose the upward variance based on the fact that it violated the mandate. If the court thinks a piece of the puzzle or the factors that he used is problematic, I suppose the court could remand with instructions to not consider that and redo the calculus, and whether that changes. But I would really emphasize to the court, this court has stated when you're talking about the district court's consideration of 3553 factors. There's the kind of evidence the court can look at. It's very broad. And here, this district court judge sat through 2 very long trials involving him. He saw evidence twice.
Situation left him on his feet, having to figure out whether he was responsible.
And Your Honor, the Supreme Court's decision, Irizarry, addresses that. I understand because for variances, the rule for giving parties notice that exists for departure does not, Supreme Court held, it does not extend to variance. And the Supreme Court recognized there are going to be instances of unfair surprise to the defendant having to the government. But the solution is not to extend the notice requirement to variances. The solution is for parties to ask for a continuance or make an objection. And as far as I can see in the record, I don't believe Ms. Appellant objected on these grounds. And this court case nicely, I think it's on point. There, the district court imposed an upward variance. There was not notice was given, but the court said he could have asked for a continuance, or he could have objected to the factual, to what he believed were factual errors, but he did not do that and decided to resign.
My final question is, can you cast light on this life without parole? I just understanding.
Life without parole. Parole is abolished in federal system. So life means life. Means life without parole. I mean, there's no way to get out for life. It's essentially my understanding of the federal system. So all of us involved.
Is there a guidelines equivalent of life that's numerical, something like, and is that what?
Mr. Mr. Hart, quote, said sentence the commission has determined it to be 170 months, I believe. I'm not sure when that, I don't think that amount of time that, I mean, once you're in jail for 470 months, I don't think you get released. I think that's just a way to quantify what life usually means. I suppose it's an average. I'm not sure enough. That was my understanding. It's not my understanding that you reach 470 months and then that equals life, and so you get it.
I guess one way of understanding what Mr. Hart is asking for is that as a life sentence, perhaps the district judge would give them a determinate life sentence. Obviously, that's the argument. That's it. So, thank you for your clarification.
If there are no further questions, we would ask that the judgment of the district court be affirmed. Thank you very much. It's really was a pleasure to be back here.
Council had no time remaining.
Okay, 2 minutes. Thank you.
2 minutes on the following points. The 2018 Miller opinion did not disagree with the enhancement. In fact, it went out of its way to say, we don't disagree with the enhancement. It went out of its way to say it doesn't cast any doubt on the evidence to support the enhancement. The only thing the 2018 Miller opinion did was tell the judge to cross the T's and dot the I's, and that would be sufficient for this court. It was not the decision of this court that the district court could not make that determination. The decision not to cross the T's and not to dot the I's was made by the district court, not by the 2018 Miller opinion. The district court is what made that decision that prevented its use to give the appellant life under the guidelines. So to say that the red language permits it because of the result, that was not the result of this court's 2018 opinion in Miller. It was the result of the district court's decision that it could not meet the requirements of the sentencing statute. The second point I'd like to make is we would vigorously disagree with respectful counsel's description of this was a case of where the murder people stood in their way. That was her characterization of what the district court thought it was doing for the original murders, for example. There is no evidence of that in the trial. Every violent act Mr. Miller was accused of, he was acquitted at trial. That's a broad overgeneralization. And the question was, the question was, the district court had seen the evidence and it knew best what to do.
When you say he was acquitted of every violent act, what are you referring to?
Well, there were some assaults. They were involved in, I believe, the RICO predicate act. There may have been something in the conspiracy count. I wasn't trial counsel, but none of those came up as part of the appeal because he was acquitted here.
But as you know, in sentencing,
Yes,
acquitted conduct can be considered.
I'm sorry, I didn't mean to interrupt. Yes, I did. But that's why he was not involved in the sentencing originally, because it was never brought up by the government in, say, 2016, where we believe it should have been. The final point I'd like to make is that I don't think this court will find in either briefs, any cases in this circuit, where there's been a variance up to life without parole. The reason for that is because district courts in this circuit have never dealt with it. And there's a reason for that, because it's the most extreme measure a district court can do, and it requires the most extreme case that's justified by the district court to impose that penalty, and no court in this jurisdiction found that to be the case. And that was
Mr. Hart, you were appointed by the court to represent Mr. Miller. And we thank you for your assistance. Thank you. You can call the next case.
Case number 21-7034, Leonard A. Saxon Associates, BC Appellant versus International Monetary Funds. Mr. Spence for the appellant, Mr. Newland for the appellate.
Good morning, Your Honor.
Let me ask you a question. Counsel, have you been tested so you don't have to argue with mask on?
Unfortunately, Your Honor, we're visiting family this weekend, and I have a daughter with severe autoimmune disease.
Understand.
Thank you.
Well, try to speak loud because I have a hell of a time understanding.
I realize it's hard without being able to see somebody's mouth.
Exactly.
I will do my best. May I please the court? My name is Donald Spence. I represent the appellant Leonard A. Saxon Associates, BC. This is a case about a contract between a lawyer and his client. On this contract, the IMF waived its immunity for disputes with this lawyer. It agreed to arbitration to resolve those disputes and incorporated the American Arbitration Association rules of the District of Columbia law. The only question here is, looking at the plain language of the contract, whether the dispute resolution clause includes judicial review of the arbitration award. This is a straightforward question of contract interpretation. The fact position is that the IMF, as it is permitted to do under its arbitration agreement, expressly waived immunity for purposes of resolving dispute by incorporating the DC law and rules. Both provide for judicial review of the award. The IMF makes three arguments as to why there is no judicial review. First, the IMF agrees that DC law applies, but it claims that the right to judicial review under the DC code is certainly a part of DC law. The Uniform Arbitration Act is not. The contract doesn't say that. It doesn't provide any limitations with regard to the applicability of DC law. It simply says in pertinent part, quote, the arbitrable case shall be decided according to the law of the District of Columbia. Secondly, IMF argues that while it agreed that AAA rules apply, and in fact the parties did go to arbitration here, it claims that AAA Rule 52C does not, Rule 52C, in fact, provides that an award can be confirmed by a court, civil, state, or federal court, and jurisdiction. There's nothing in this contract that excludes this rule or any other AAA. Our brief cited the case of California Parking Service, where the contract that drafted specifically excluded the applicable AAA rule relating to judicial review. Contract in this case is.
But why doesn't it, Mr. Spence? Because it has a reservation of immunity, even in the arbitration clause. So why isn't that, in effect, saying we will arbitrate, but without any assistance, confirmation, enforcement, impulsion, or subpoena assistance from a court?
And that's my next argument. And here's why. If you look at the specific language of the arbitration clause, you start at the top of section 20.1. And it's an observation with regard to the IMF's existence and immunity. It talks about the statutory basis of the IMF and that the IMF has immunity from the judicial process. But what it doesn't do, this is an introductory paragraph, what it doesn't do is specifically state that the IMF is not waiving immunity under this particular contract. It's an observation or a declaration, it's not a direct promise. And if you look at
Well, at the end of the clause, doesn't it specifically make the point that Judge Blake just made?
it does not, and I'll tell you why. The end of the last sentence is understood and agreed that the submission of a claim or dispute arbitration shall not excuse and shall be considered waived. The act of
I notice how your voice just trails off.
I apologize, sir.
I mean, it trails off to you.
I will keep it up. The act of submission or dispute, the act of submitting the claim itself is not a waiver. And that makes sense, Judge, because if I submit a claim, that's not the essence, that's not the essence of what I'm looking for. When it gets to award, there's where the waiver is. But what they've done is they've taken this very narrow act, submission of a claim, and said, that doesn't waive your immunity. That makes sense. It's an internal conflict.
What could it be referring to, if not immunity relating to the arbitration that this subclause contemplates?
It's not addressing the award. It's not addressing the confirmation. It's not addressing the arbitration, the hearings.
My question is why not? It says submission of a claim or dispute to arbitration shall not be considered to be a waiver of the immunities of the IMF. So if it isn't saying submission to arbitration continues to exclude any and all court involvement, what is it there?
What it's saying is when I submit my claim, and I say you owe me X, that's not a waiver of the immunity. It stops there. They're all they're talking about is what I submit. That they're saying just because you said it doesn't mean so.
So it's guarding against counterclaims. You need to be more specific. I'm not sure what you're talking about.
It's saying that regardless of what I submit, that until I go through the process, there's no waiver.
Who's I?
Me being the claimant, me being the protector. So I have a claim I submitted. That's my submission. There's no waiver at that point. Then we go through the arbitration process. Then an award is issued. There's where the waiver is. Because there you've adopted the AAA rules, you've had proceeding in accordance with those rules, and an award has been issued.
Counsel, so, I'm not sure I agree with your interpretation. But if let's assume it was ambiguous, what happens under the article of law?
If it's ambiguous, the IMF is the drafter of this contract.
I'm sorry?
Ambiguity goes against the draft.
Well, no, wait a minute. What's the general law here? Doesn't it have to be an explicit waiver of immunity?
The explicit waiver of immunity is above the clause below.
No. This is generally, there has to be an explicit waiver.
I agree.
So if there was ambiguity, which I don't think it is, but if there was ambiguity, you lose.
I don't agree. I think there's enough of the ambiguous sentence is actually the sentence that starts accordingly and notwithstanding anything in the contract.
I'm talking about the whole interpretation. The best you could make it would be ambiguous. And if it's ambiguous, you lose, right? It is correct, isn't it?
It is correct that if I cannot show that there's been an express waiver, I lose.
Well, that's what, so if it's ambiguous, you would lose.
I don't think that it goes to the waiver itself. I think it goes to procedures with regard to the process.
No, no.
Well, it's clear from the contract that we go to arbitration. It's clear from the contract DC law applies. The idea, it's clear that if the arbitral case is governed by DC law or decided by DC law.
What does DC law get you in terms of this question about arbitration enforceability? In terms of the arbitration process, isn't DC law granted by the Federal Arbitration Act? The DC law is just something like a substantive contract, no?
It means whether you talk about the Federal Arbitration Act or the DC law, the result's going to be the same. Those acts would have the same impact on those states.
I thought you were relying on DC law to support your enforceability, modification, and making sure.
Yes, and I am, because I believe that the contract says I have to rely on DC law. And so that's why I'm doing it. What DC law does for me is it provides a review of the process. If you look at the process of confirmation, modification, or vacation of the award, those modifications or vacating an award goes to, was the process fair? Was there evident partiality or was there some refusal to consider superior evidence or alleged here? And so that's what DC law does for me. And what you look at here is the article of law will be decided according to the terms of the contract of the law of the District of Columbia. You can't just say, okay, well, some law applies over here, but I'm going to ignore this DC law with regard to the statute over there. That doesn't make sense. You've got to read this thing as a whole. That's what DC law requires, that all terms of the contract be given lawful effect, reasonable lawful effect. Meaning. If you stick with the IMF's interpretation, what you're doing is you're reading out Rule 52 of the AAA rule. You're limiting DC law.
Reading out what?
You're reading out Rule 52 of the American Arbitration Rules. You're reading out DC pieces of DC law by saying that the DC Uniform Arbitration Act doesn't apply, and you turn the last sentence in this section into surplus because there's no reason for it to. There's no reason if you have blanket immunity, then why are you putting a clause in here? It's protecting yourself during the submission of the claim thing. And that's the thing that doesn't make sense. You've got to read this document. I mentioned the California Department of Services case earlier. They're the draft of the contract specifically excluded certain purposes, the AAA rule we wanted to do review. The IMF drafted this contract. If they added that sentence, it would be clear to my client, clear indication to my client up front that the ramifications of an unenforceable, of the ramifications of an unenforceable arbitration rule. SAC didn't get that chance. That language is in India. The language in here, the reasonable interpretation is that DC law applies, that AAA rules apply, and that's the proper interpretation.
Great, thank you.
Good morning, may it please the court, James Newman for the International Monetary Fund. Before the court, we ask the court to affirm the district court's order because the plaintiff has not established that the fund has expressly waived its absolute judicial immunity as required by not only its parties agreement.
I take it to the argument that if after the arbitration had ruled against you, you could say, go pound sand. You know, we're not going to do it.
But they haven't. I mean,
No, counsel. You give them a hypothetical, the worst answer you can possibly give them is not this. So, why don't you deal with mine?
yeah, in theory, Your Honor, they're absolutely immune from every form of judicial process. That's
The answer to my question is you can say, go pound sand.
They couldn't be held in court to enforce the award for sure, which I think is the answer to your question. They could say go pound sand, but they haven't. And even if we get into these types of policy discussions, whether that's fair or unfair, all of those policy considerations were decided in 1945 in Breckenridge, New Hampshire, right? Where the fund negotiated for absolute immunity. All of the member countries at that time agreed, for policy reasons, that the fund's absolute immunity from every form of judicial process is critical to its role in the international marketplace. So we don't get into these policy determinations with the fund as Jim points out, negotiated for absolute immunity, absolute component waiver.
Mr. Newland, how do you square your position with the Supreme Court's decision in Enterprises, where the court said the arbitration regime has to have a real world objective? It's not designed for the recognition of gain lacking practical consequences, and basically saying arbitration without a waiver of immunity to the extent of reducing it to a judgment is just not arbitration at all.
I think two things, Judge Miller. First, CNO Enterprises is clearly distinguishable because in that case, the contract itself, right, not for arbitration or anything else, the contract itself said you can reduce this award in any court without to a judgment, any court having jurisdiction.
That's true, but interestingly, the court really doesn't focus on that. But you're right, that is a distinction.
Yeah, but so if they found a tribal waiver, and then they go to this point about policy determination about what it's an arbitration without a rule, and they say that I think right at the end of the court they also had that the contract here again, like in how we get Silberman, any policy determinations about whether that's fair or not were decided and not for this court to revisit, I suggest. I mean, here, the plain test and jam in particular is that there must be an express waiver that the IMF negotiated for absolute immunity.
Nobody questions that the default is waiver, and that there, I mean, the default is, I'm sorry, immunity, and that it cannot be vitiated in the absence of an express waiver. Really, the question here is there is an express clause providing for arbitration. What are the implications of that? And I take your position to be that the arbitration in this contract is basically a potential aid to voluntary settlement and nothing, that there is no ability of any counterparty to the IMF to compel arbitration under this law, to seek a witness, seek a court assistance, witness under this clause, or to confirm or enforce an award rendered by the AAA under this clause. That's your position.
I think that's certainly consistent. Absolutely.
Is that your position?
It is, and it is.
So binding arbitration, in what sense is the reference in the contract to binding arbitration binding? They can't be enforced in court. They can be completely ignored.
No, I think the point there is exactly reinforces our point, and that is the arbitration itself is final and binding. Those are words, by the way, that are in the standard arbitration clause. They were added to reinforce the point that the arbitration is the end. As it
Well,
should be.
final, but it's binding in what sense? It's no binding. This is with God.
No, it's binding on the parties. The arbitrator's result is binding on the parties. And in this case, that's exactly what the fund did. They had an arbitration. They went through it. They didn't say we're not going to arbitration in these cases with other defendants. Here, the fund went through arbitration. It received an award. It was adverse to it, and it tendered payment to Mr. Sachs. That's the end of it. It's final and binding. There isn't a mechanism. When you have absolute immunity absent your own express waiver, there's no mechanism to revisit whether that's a good policy or not. And I think what the plaintiffs attempt to do, or what Mr. Sachs attempts to do, is argue for a policy exception and that the court should make a policy determination and use that to overturn the clear language of a treaty enshrined in a federal statute and reinforce the contract.
I don't read his to making any of those arguments. I read him to be arguing about what it means to agree to arbitration.
It means exactly what the contract says. That arbitration is the end. That notwithstanding the submission to arbitration, there's no waiver of the fund's immunity to the judicial process. That's crystal clear. And by the way, it also says in the opening, these are our immunities. They're incorporated into federal law and DC law. And accordingly, this is what we're agreeing to. We're agreeing that we're submitting to arbitration, that the arbitrators themselves will apply DC law in the arbitral case. Nothing more, nothing less. There's nothing here. I think Sachs urges that there's a contract choice of law clause. There isn't. If you look at CNL, there is a contract choice of law clause. The contract itself says, well, the contract will be covered by the place of the project, the path which is enacted.
Is the contract at issue here a standard contract? The IMF usually with other vendors or
See, it's the one I saw. Same time. It is. Yeah, I'm not saying it's the only one they have. It's a huge organization around the world, but it is a standard contract for professional services.
You say in one sentence of your brief that the IMF's executive board would have to waive the IMF's immunity, but I didn't see anything other than the affidavit that supported them. In fact, the bylaws and the articles of agreement that are referred to don't have any reference to this process. Can you help me find out where that is supported?
Absolutely. If you go back to the articles of agreement, and I believe it's actually in Article 12, Section 2, all powers that aren't directly granted to one of the organs get granted to the Board of Governors. Here, internally, the Board of Governors has granted that to the Executive Board in 3A of the articles.
What?
Requiring that any waiver of the fund's judicial immunity is done through the Executive Board.
So if the arbitrator were corrupt and were bribed to reach the holding, that's something that potentially the Attorney General could go after, but not the county.
Counterparty. Yeah. Fair. And in this court's case,
Sorry, I didn't hear you.
and Leonard, which
I didn't hear Judge Williams' question.
Judge Pillar's question was if there was some kind of misconduct on the part of the arbitrator, fraud, bribery, that type of thing, that the counterparty couldn't go after, try to go after couldn't come to court and vacate the arbitration award. Perhaps DOJ was someone to go after the arbitration. I confirm that that's consistent. So I think the last point I'll make is a moment of time is they do talk about Rosebud here. And Rosebud, I think, is not on whether the first Rosebud doesn't have any of the express preservation immunities language that we find not once but twice in the arbitration clause. Rosebud also talks about an express waiver standard that I don't think is consistent with this court's view of what it takes for a foreign sovereign, which again has a lower level of immunity than the international monetary fund, which has absolute immunity, what the standard is for an express waiver. And here what they've asked you to do is look at this clause and do what you shouldn't do under the preamble, and that is look for clauses of parts that are in tension with each other or suggestive of waiver. We don't have any of them. There's no explicit express waiver anywhere in this contract. And in fact, the clause itself preserves the immunities. And with that, we ask the court to affirm the district court's.
No time.
Thank you, Ron. Just 2 points. One is, if you look at 3.1, you have to look really hard to see that that's express protection.
That's a reversal.
Right.
Reversal protection.
You're right.
You didn't want to say that.
I did not. Express. I think there's 24 seconds in that. An express assertion of the immunity. It's not. It's an introductory clause. It says, hey, we have the meeting. We're breaching the statute and we have them. That's all it says. And then when we go to the accordingly notwithstanding anything to the contrary of this agreement, it is expressly agreed and understood. And there follows the waiver. There follows the AAA rules. There follows the law district. With Rosebud, Rosebud does, and it applies in this case because it shows that this court can consider modification of vacating under these identical circumstances. Finally, CL Enterprises, that case applies. The distinction about the body of the contract.
Yeah, but the problem with that's what it is. Then that there was a specific reference to enforcement of the arbitration.
That identical reference is in Rule 52 of the AAA rule. The same. That's all I think.
Call the next page.
Maybe go to my mistake.
Case number 20-1325 et al. The City of Miami, Oklahoma petitioner versus Federal Energy Regulatory Commission. Mr. Gosset for the petitioner, Ms. Rylander for the respondent, Mr. Zetling for the intervener.
Good morning, Your Honors. May it please the court. Residents of Miami, Oklahoma have, for the last 30 years, repeatedly had their homes, schools, and businesses flooded because of the operation of Pensacola. In the orders under review, the Commission erred by continuing to kick the can down the road, failing to hold GRDAs to the terms of its existing license, and thus requiring GRDA to obtain flow resistance within the sand. I hope to touch briefly on 4 points in my limited time this morning, unless the court directs me elsewhere. Standing, Section 7612, the evidence before FERC, and FERC's referral of these issues to the license. On standing, GRDA argues that the city lacks standing because its injuries are not redressable given Section 7612. This puts the cart before the horse and has no case support. Indeed, it's contrary to the logic of the Supreme Court's decision in Seal Code that they themselves cite. If the city's reading of Section 7612 is correct, FERC has the authority to grant us the relief we seek, and thus can redress the city's injuries. Indeed, the distinction from the Wilderness Society case on which GRDA relies could not be more stark. In that case, the point was that the court could not order redress of the Wilderness Society's injuries because, according to the Wilderness Society's views of the statute, all that the agency, the National Park Service could do was request that the president request that Congress, in Congress's own discretion, designate certain lands as a wilderness area, not that the agency could designate those lands. Here, under our reading of the statute, FERC could and should do this.
In other words, it's saying your opponent has taken a hard decision in terms of contemplating this thing.
Precisely.
You know what I'm most interested in is the last point. The first position that we're going to take care of this in a lifetime down the line. Well, we should have discretion as to what procedures we use. We don't have to deal with the enforcement of the existing ones. We're going to take it up in a future one.
As now Chair Lick of the Commission said in dissent, it's a dereliction of the Commission's duty not to hold GRDA to the terms of its current license. It's not the case that
Isn't this a specific proposition of administrative law that once described as an administrative shell game, if an agency took a position with respect to enforcement of existing obligations, and instead we'll take it up in the future rulemaking? Are you not familiar with the case? I'm a little offended about it, so I wrote it. The Supreme Court
I'm not sure which case you mean, but it's certainly a proposition that we agree.
AT&T versus MCI.
Oh, sure. I am familiar with that case.
Why didn't you cite it?
What?
Why didn't you cite it?
I'm sorry, Your Honor. We should have. There were more recent cases of the court addressing the same point, though it is certainly a similar case proposition.
I don't recall which case you were referring to. So in the Supreme Court. Except that that case was affirmed in the Supreme Court.
That the agency can't play these sorts of games.
Well, Scalia described it as I described it as an administrative law shell game. An agency cannot take a question of whether or not there is a violation of an existing rule by answering, well, we'll take it up in a future rulemaking. Because that's future, not existing. Your argument is this is a violation of the existing license. So it's not separate to say we'll take it up in a future license. Is that correct?
That is correct, and we should certainly have cited that case, Your Honor. We did make precisely that point, and in response, the commission basically said, oh, you keep on saying this, we keep on saying we'll handle this later, and that is a shell game in a different sense, in that it's just putting the burden of this flooding on the city of Miami over the course of the last 30 years, because the city keeps on coming to FERC and keeps on coming to GRDA and saying, please help, and they keep on saying, well, we'll deal with you later.
Well, in other words, your basic argument is that the agency's position that will take this stuff in future rulemaking, future licensing, will take this stuff in future is a non-sequitur. It's a non-sequitur because you're claiming that the existing license is violated.
Yes, Your Honor, and their response is, we can do that nonetheless, and I agree that that is a non sequitur and that they should not be allowed to do that. And just because the same question may be relevant in relicensing doesn't mean that they don't have an obligation to determine it now too. Indeed, the question whether GRDA is abiding by the terms of its current license is itself a relevant factor in the relicensing process. Among other things, it is one of the standard factors the Commission looks at to determine the length of a new license if we were to grant a new license between 38 and 50 years, or whether to grant the license in the first place. So I do agree that it's a shell game in addition to being unfair to the city.
Now, what about the statute that Congress passed, which the agency claims deals with, or I'd say the MD argues that it affects standing. What about that statute? Do you think it's perfectly clear what it means?
I do not think it is perfectly clear what it means. I do think that that's important in two ways. First, of course, the Commission hasn't asserted an interpretation, so they don't get temporary deference. But also, the lack of clarity is why the Article 28 rule against, essentially codification of the rule against repeal by implication comes into play. It's not clear. There could be an interpretation of this provision under which we wouldn't be allowed redress. But because there is another interpretation that we have provided under which we are entitled to redress, and the Commission could order that redress, therefore, the Commission erred by not so interpreting.
The basic point is the agency hasn't interpreted this language.
The agency hasn't interpreted it. That is a separate delaware.
You are for remand.
We are arguing for remand. With bacon, but yes. We do think that there are sufficient errors in the order such that the court can also direct that remand in ways that will help direct the agency to proceed accordingly, such as, for example, not deferring for relicensing.
This is not with respect to the interpretation of the language. We can't interpret that language ourselves. So
I do think the court can interpret that language. I mean, it's for the court, but I think you could also choose to.
But you can see that it was ambiguous.
But the mere fact of ambiguity when the agency has an asserted ambiguity or desire for difference shouldn't preclude this court from interpreting the statute to not bar our complexity.
But your basic argument was the agency never interpreted the language at all. So that suggests you were claiming that it had to be remanded.
The agency never interprets the language, but also asserts that irrespective of everything else in the order, the language would apparently deny relief, which we think is an alternative basis for the ruling against us. There is no explanation whatsoever for that interpretation, which violates principles of reasonable decision making. But it is also, the agency's counsel, my friend Ms. Wagner, has said that the agency didn't rely on the statute. So I think the court should also accept this proposition.
Can you explain, if we're going to remand, and you said with some assurances, for example, that they shouldn't roll this into the rulemaking, were we to reach the meaning of 7612 for some of the reasons that you specified, how would you interpret it not to preclude relief? On the merits, assuming we don't.
The fundamental flaw with GRDA's interpretation of that provision is that it asserts that project boundary is a term that limits the commission's obligations. It is not. The commission's authority over GRDA's obligations. It is not. The project boundary is a descriptor that sort of has existed for the last 20 or so years to make everyone's life easier to understand what land is relevant. But it is not, doesn't limit Article 5 or otherwise limit the Commission's authority or GRDA's obligation. And therefore, the provision that says the project, you can't change the project boundary, or the project doesn't include changing the project boundary, doesn't have that effect.
So you're saying it doesn't limit enforcement under Article 5, and are you saying even if enforcement under Article 5 were to require acquisition of land or flowage rights on land, once that land is acquired, it doesn't necessarily affect the project boundary? And can you elaborate a little bit more? And I see you nodding. Thank you. So what does the project boundary refer to distinct from the scope of rights and inland that are in the control of the authority for the purposes of the project?
In an ideal circumstance, the two are fully aligned. The Commission in 2003 amended its regulations about project boundaries to say we should have the project boundary fully encompass the land of the project. Before that, for example, minor projects, which are minor license projects, didn't even have a project boundary, which goes to the question of whether it's relevant. So they should be the same, but they aren't always, because it is simply for the ease of everyone to know what the project encompasses. So this is, we cited in our reply to the.
My understanding of your point all along has been the project boundary is not a limitation on the obligations of the licensee.
Yes, sir.
So therefore, any direction in the statute of the project boundary doesn't necessarily resolve this issue.
Yes, sir.
But it's a little confusing, a little ambiguous. But anyway, the project, your basic argument is project boundary is not a boundary of the obligation.
Correct. It is a descriptor of the primary sort of land or and rights relevant to the project, and often includes all lands relevant and all lands with no obligations. But the riparian rights cited in our reply brief is where the Commission specifically said we can order you to do things outside of the project boundary, and that's still an obligation to acquire rights necessary for the execution of the project. That's the same thing here.
I think FERC conceded that point.
It does. It said in the staff letter order that the project boundary does not limit the scope of Article 5, and the Commission in its hearing order did not revisit that assertion. If there are no other questions at this point, I see I'm significantly over my time already.
I just want to ask you about the Principal Act, which uses project boundary, and then this second prohibition says any land, water, or physical infrastructure or improvement outside of project boundary is not to be considered part of the project. How do you read that?
We read that to be essentially the same as the first. It's what is part of the project is defined as
It's
the project.
talking about a different area. Any land, water, whatever outside the project.
Yes, Your Honor. And with respect to that land is not part of the project. I think one way to understand that is instructions not to amend the project boundary to include any such land, but it's still the case that obligations of the licensee can extend beyond that. So for example, downstream effects of a project are regularly considered obligations of the licensee, but that land is never considered part of the project. So here, I interpret that as being more about which lands should be considered part of the project within the project boundary. The next one says you can't amend the project boundary without the licensee's agreement. All of these, back to Judge Silberman's point, are ambiguous. There are multiple readings of these, which is why I think it's a tough case that for the commission that they have never provided an interpretation.
Plain as it can be, there's no licensing. Period. I'll give you some time.
Thank you.
Ms. Byron?
I'd like to step back. You're having trouble hearing me? Good. I'd like to step back for a moment to consider the issue of reserve reviews. And the first thing was whether there was a violation.
Can I ask you to raise the desk so I can hear you better?
That's the kind that goes.
That's fine, it works.
Okay. I'd like to start with the question of what is reserve review in this case. And the first thing is whether there's a license violation, and the second is how the Principal Act applies here. Petitioners did not preserve for review the issue of whether it was appropriate for the Commission before this issue the issue of upstream flooding to be licensing. That does not occur in the hearing. And in fact, it is appropriate for the Commission for the issue of upstream flooding to a broader and more comprehensive proceeding in which it will consider all issues related to the license, including upstream flooding.
That doesn't answer the question as to whether there's been a violation of the existing license.
That's correct, Your Honor.
And that's why I'm concerned about, are you familiar with AT&T versus MCI?
I wish I was, Your Honor.
Well, that stands for the proposition that an agency cannot avoid answering the question whether there's a violation of X by saying, well, take it up later in the rulemaking. That is what I describe as, we describe as administrative shell game. The Supreme Court used the same thing. In other words, it's a non-sequitur. Goes back a little bit to wine and Gordon.
Your Honor, I would not say that there is any shell game here at all. It is, the Commission has considered the issue of upstream flooding in the number of times. At the time this complaint was filed in late 2018, it had already ruled that the issue was best considered comprehensive proceeding. It is not actually, it's not eliminated, as you're describing, the licensing.
Licensing doesn't look at the future.
Yes, sir.
That, in that respect, it's similar.
But what it also the process of making this examination requires further study and upstream conditions. And the Commission already has Commission Sound J, which fits in the in the study plan determination. The comprehensive study that gets to the causes of flooding. That study is going to take several years, and at the time this complaint is filed, the Commission has already ordered the study to occur in the license. And as explained in the hearing order, it doesn't make sense to take a single issue, proceeding that is already being considered in regard to
broader proceeding that keeps clearly.
Why not, Ms. Rowland? It would seem that the AT&T principle that a claim to an existing license is being violated is a distinct matter from an upcoming relicensure. And if the commission were to do the work that it contemplates doing on the causes of the flooding in the context of the former, it could very well rely on that same study for purposes of the relicensing. So I don't think this issue. The question is whether a challenger like the city in this case has an entitlement to get an answer to the license violation that is raised.
Yes, Mayor, certainly it does. The commission has answered that question. The commission answered that question when the orders were in here and also explained where it was going.
It was a question by saying that there was no substantial evidence of that the flooding was caused by the project.
Yes, sir.
You're not.
How do you ignore, excuse me?
Go ahead.
How do you just ignore the Oklahoma court proceeding, which extensively discussed evidence?
Your Honor, you're correct. The court did not, the commission did not describe the Oklahoma proceedings.
You ignored it.
I am left to infer from the record that the proceeding there found liability based on Oklahoma statutes, and it did not address the question of whether the license was violated.
No, of course not. It did go over the evidence as to whether or not the dam overflow caused the damage.
Your Honor, I looked at the Oklahoma proceeding did consider some of the same studies that the commission did. The commission's distinct finding was whether the studies showed that there was the commission looked at some of the same studies that the Oklahoma did, but it was looking at these particular purposes, which dealt with the appropriate level of the lake surface and not
The level of what?
the surface of the lake.
The question was whether there wasn't flooding of the town of Miami.
Yes, sir.
But the same issue with both proceedings. Or at least it should have been before you, before FERC. I get the impression looking at the record that FERC just totally ignores the evidence of flooding in the town of Miami.
The commission explains in the hearing order paragraphs 13 and 15 and in notes 21 and 24, dated pages 1995 and 1998, that it was familiar with the evidence presented to the commission, that it was familiar with the evidence presented to the commission. And we have seen in previous times with regards to this license, it was clear that there was litigation in the state of Oklahoma.
But there's no, I mean, there's not any discernible response to it. And it's actually quite odd when you think procedurally that the commission then adverts to an assertion or allegation by the authority that it disputed whether the project caused flooding. But that's comparing apples and oranges. The city comes forward with evidence referring to the two studies, a little bit more studies, the Holland study and the Center Tech study, and said, look, we have studies that these are the conversation matter conclude that the flooding of the city is caused by the project. And then FERC seems to hear the authority in response saying, we disagree, and accept that as an absence of threshold evidentiary showing on the city's part, which just seems to me not to be one. So, what's your response to it? Characterizing it, missing something for procedure, it just seems arbitrary on folks' part to have so concluded based on the complaint and response.
I would emphasize again that the commission has taken these allegations seriously and has addressed them and explained it in some paragraph. 21 of the hearing order.
addressed issues of statutory reporting a number of times and intends to do so again in the future. It's not clear how taking a separate one here is going to provide any further benefit to the city of the commission had already done prior to filing.
It's just our obligation to apply the law, and if the law requires that this be addressed as a complaint and not rolled into a future prospective proceeding, then that's what we do, whether it turns out to be convenient for the commission or not.
But the law does not require that this is addressed as a complaint. Commission, this needs to address it together with not having here, the triggers and ambiguities of the violation often reported to the compliance division. The compliance division has authority to investigate and to rely, and as explained in the brief, it can rely on proceedings to inform decisions.
So it relies on past decisions, including the current order, which, as I understand, looked at a much narrower question, which is just whether the proposed increment of water level would cause flooding. And the city's response says, no, the flooding caused whether that additional increment is permitted or not, and for never purported to address the underlying cause of the question.
Indeed, a FERC proceeding that's FERC specifically limited its inquiry. Didn't it?
I would ask to, are your owners speaking of the 27th for proceeding there?
Yeah.
And your honor is asking the fact that dealt with increment.
You were the one that said that the commission had at various times addressed this question. I heard that you were talking about some of those proceedings. I'm not aware of any time when the commission has addressed this question. And so one response to your this would be an efficient argument is that's an inefficiency of the commission doesn't make having in Commissioner Glick's or now Chair Glick's terms kick the can down the road for this.
Speaking your question as a question, like your honor, the commission just wasted time. There's nothing we can do about that now. We can have an overview.
What did you just say?
If I'm taking this question, Judge Fuller's argument, the commission has been wasting time.
The commission has wasted time.
Yes, by not taking up the issue of causes of flooding prior to now.
It's not a question of wasting time, it's a question of whether you've satisfied your obligation. There's a challenge to the existing license obligation, and the challenge is before you. And the only question is whether you're obliged to decide it or not.
Crazy. Either do as Judge Fuller did or you did, Your Honor. There is nothing that the commission could have done right in the complaint or any orders of review that it had not already done in establishing the relicensing process, laying out a timeline, and providing for the study that the commission itself said in the study plan, J, page 1517, would get to the issue of what was causing the flooding.
I'm having trouble following, and it just seems like maybe we're talking past each other. You spent quite a bit of the briefing talking about how this was referred to the compliance division. I take that to be the division that deals with whether an existing license is being complied with or not. And if that's an answer in and of itself, if the compliance division finds non-compliance, what happens?
Then there would be stuff to.
Right. It wouldn't automatically be rolled into an upcoming relicensing, would it? I know your position is that it could be. I'm asking whether it was automatic. Let's say this was 15 years before the license is due to be reconsidered. Would the compliance division, they would seek to enforce in what kind of, how do they do that?
In this case, had the compliance division it's calculated some time
that there was a license, that there was a license violation, and that the license was responsible. I think the compliance division, I mean, it could have done a variety of things. It could have required the licensee to require additional land rights. It could have required original changes. I think it could have required consultation with all engineers. But I don't mean to be indefinite, but we couldn't do it. I think I can really say there's a range of I believe
You said, but for the Pensacola Act, but I don't take the order to rely particularly on the Pensacola Act.
no, you're right. It does not. It observed only that it observes only that even had the commission found the license violation here, the Pensacola Act appears to be.
That's an alternative holding.
I took the commission to be taking an even more modest position in that it doesn't argue that 7612, in the briefing anyway, provides an independent basis to affirm, but says only that it didn't affect the outcome of the agency proceeding. It wasn't harmless error here. Is that the commission's position?
The commission's position is that the Pensacola Act is not necessary to fully clear the license.
What was its language? What is the exact language in the FERC's opinion dealing with Pensacola?
Again, in the framework, paragraph 18, point to page 1936. Notwithstanding the foregoing, i.e. special license violation, much of which took place before the passage of the
Please speak now.
I'm sorry, Your Honor, I'm trying very hard. That actually precluded the commission from granting relief to the city of Miami.
That would preclude us from granting leave.
Yes.
Notwithstanding the above, that sounds like an alternative holding, isn't it?
I'm not saying it needs to be captured that way, but it could be read that way.
I'm trying to reconcile that with the red brief, which says that claims about the act only that it did not affect the outcome of the agency proceeding. And then the brief discusses this at 42 and 43. And so I took that to be the first position was that it's not relying as a merits basis to defend the order, section 7612, but basically saying even if it's error, it wasn't in the mix really in any way.
I agree that the red brief is inconsistent with the order, isn't it?
I certainly didn't intend to.
Well, if we see a difference, what should we rely on? The order itself, or the order?
Where it sees a difference, the commission speaks for itself within.
It's the order that you rely on.
Yes.
Right. Okay.
And if the language of the red brief doesn't convert that, which should certainly occur, we should flush that. All right, effort.
This Brennan, I don't know what law is, but I'm interested in what I think is speaking of the law, the original question. And that's the core of engineering. You deliberately throw that in, said the issue of whether and to what extent GRDA and FERC are respectively responsible for flood control operations is not presented by this case. Do you know what, if any, authority FERC goes over the Corps. And I think I'm right, that it's up to the Corps to direct release of water.
Yes, Your Honor, you're correct. The court has no, has no authority over the Corps of Engineers. And the Corps of Engineers directs the use of water when the level of Grand Lake rises.
Does the Corps of Engineers have any responsibility for dealing with flooding in the city of Miami? I was curious about that question too. The intervener seems to suggest, not the intervener, yes, the intervener seems to suggest it's the Corps of Engineers' responsibility. Is that true?
The intervener certainly would suggest, because the intervener has alleged for many years that it's not responsible. The commission does not know who is responsible. The commission is again, the only process of trying.
But the commission does know that it's the Corps that releases the use. Commission knows that.
Yes, and it's made out in the memorandum of understanding and repeated many, many times through the commission's order. I would, I'm sure the court has seen it, would direct the court particularly to the 2017 report for the RFC for JA pages 1384.
No more questions. So here for Mr. President. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. Nisha Pittman for GRDA. I would like to thank the court for allowing me to have 5 minutes to talk about the Pensacola Act. I think this court is clear that whether this court looks at this as a matter of article standing and reversibility, or as a matter of reviewing the FERC's order, that this court needs to make a final determinative decision on the meaning of the Pensacola Act here. I think as the colloquy with my friend and Judge Silberman made clear, paragraph 18 of the FERC order could not be clearer that they made a final decision on the meaning of the Pensacola Act and interpreted it the way that we did. In fact, what happened here is that the city and GRDA had a disagreement in early 2019 about this very issue that you all were talking about with my friend, about whether the FERC could require GRDA to purchase flowage easements outside of the project boundary. CARS saw this disagreement and in late 2019 entirely resolved this in unambiguous statutory text. And I think there are 2 provisions of the Pensacola Act that both independently resolve this issue in a matter, to borrow your phrase from earlier today, in a matter of belt and suspenders. The first provision is FERC shall not, the jurisdiction of FERC, licensed jurisdiction of FERC shall not extend to any land or water outside the project boundary. Here, my friends are saying that FERC, you should enforce your license, that licensing jurisdiction, outside the project boundary. That was their argument before the Pensacola Act, but now the Pensacola Act cut that off at the knees. That argument is no longer available. Second, if the court has any doubt about the meaning of that phrase, the immediately next phrase is, quote, land outside of the project boundary shall not be considered as part of the project. So what does that mean? Now, it's a good question. The project, well, the project is defined in the federal code at 16 U.S.C. 796(11) as land necessary or appropriate for the maintenance or operation of a project. That is the exact same language that is in Article 5, necessary or appropriate for the maintenance of the project. It is linguistically impossible for something not to be part of the project, but then to fall within Article 5. That's why I say belt suspended. The first provision I read says FERC's got no jurisdiction. That's clear as can be. If your honors have doubt about that, FERC can't go outside the project. We have the statutory definition of project. And if you need to add an extra strap on those suspenders, you can look at the couple of provisions after that. They say that FERC can't change the project boundary unless it gets our written permission. So that makes crystal clear what those two provisions say can't be overcome by FERC somehow changing the project boundary or trying to strong arm us to do that. They need our written consent. So we can.
It's a well-put argument, Council, but FERC hasn't adopted it.
Well, Your Honor, on paragraph 18, they certainly said, they quoted the relevant language, and they said that this is the conclusion. I think the statutory text is very, very clear. Certainly on that second argument I just made, the suspenders on the belt, I've given a little bit more detail, but on the first one, it's just said the FERC got no licensing jurisdiction, and that's clear as can be. I did extrapolate a little bit more on the second alternative argument, but the first one is enough, and given that it's in paragraph 18, given that I do think there's a credible argument that it is an article standing issue, I think it would be the right thing to do for this court to just interpret that act, which, I mean, this is kind of an extraordinary scenario where the parties are disagreeing about this very thing. Congress comes in 11 months later and settles, says the thing that the city wants you to do, FERC you can't do. That should be the end of the proceeding. It makes no sense to balance it back.
What makes us think that they weren't settling it for the relicensing, but not settling it now? I mean, the licensing is most straightforward understanding of licensing jurisdiction is jurisdiction to issue a license. I understand you have a counter argument that enforcement of the license is also use of licensing jurisdiction, but if we're looking at this as potentially jurisdictional, we have to be clear. And why aren't they just looking forward? Especially in light of Article 28, it says you can't change the terms of an existing license by congressional amendment.
Well, we don't think that we're here in terms of this license. We have an argument that we still believe that we were right at the time. What they did is they settled this disagreement about the scope of FERC.
Well, you're not answering those questions. Were they selling it for future licensing? That doesn't address existing license?
So I have two answers for that, Your Honor. I
That's
do.
what I thought there was an ambiguity.
Well, so that argument only refers to that first sentence, the balance. With regard to licensing jurisdiction, it doesn't say anything about that second argument, which is in paragraph 18, although not in as much detail. But with regard to that first argument, I don't think that's the best way to read the statute, and it wouldn't make a lot of sense. Why would Congress want them to be able to require GRDA to purchase this massive number of acreage of flow juices for the giant cost for the past, but then impose a limitation on for the future, so the project boundary would expand for just a short period
Maybe
of
they were
time?
suffering under the same misapprehension that FERC was suffering under, which is that any enforcement action of the existing license would be rolled into the future rulemaking, and therefore we don't need to worry about it. They're wrong on that. They just didn't. They tried to do something that didn't reach an area of exposure.
Looks to me like it could be bad drafting.
But that may be, Your Honor, but that's exactly why a belt and suspended approach is very sensible for Congress to use, because, you know, a court may later determine that it is bad drafting. So we think that first sentence is clear. But again, Your Honor, seeing that first sentence is unclear because of the use of the word licensing for a jurisdiction. I think the second sentence is crystal clear, and my friend.
Why is the second sentence not also susceptible of meeting conferring the future license?
The second sentence says, land outside the project boundary shall be considered to be part of the project. It doesn't say the land project in the future
Well, shall not,
shall not be considered.
you omitted the word not.
I apologize. It shall not be considered part of the project. That doesn't have any indication that it can apply only in the future as a present tense. And as I explained, the word project is defined in the Federal Power Act in the exact same terms as Article 5. So there's no other way to read that.
Except the FERC does use the term project different from an obligation.
But the sentence,
You see the point? FERC does use, traditionally uses the term project as a more limited term than in the obligation for the licensee assumes. My reading of, so if it's only defining the project, yeah, I see your point. You would like to refer to another spot where project is defined. But then FERC often defines the obligation is broader than the project.
Your Honor, we respectfully disagree with that reading of FERC's precedent, but to the extent.
Wait a minute, is that not true? I mean, I thought that was accepted, that was FERC accepts that. FERC's opinion specifically accepts that. The FERC brief accepts that. Reverse, that the obligation of a licensee, it goes beyond the project boundaries.
Your Honor, I think that.
Think of downstream rights. I mean, there are obligations that a licensee has that aren't conterminous with the project.
There certainly could be certain types of obligations that are imposed on a licensee, but they are not under Article 5. Article 5 uses very specific language, and that's necessary or appropriate. That's the same as the Federal Power Act's definition of project.
Well, this is not FERC's position.
Your Honor, the letter order, which my friend quotes at JA 1970, we don't read. And we think that they take that one sentence out of context. Your Honor, can look at JA 1970 and see if you agree that the letter order is properly representing their position. But to the extent that there's something in the letter order, to the extent that there's something in the letter order that's contrary to the Federal Power Act's definition of project, obviously the statute that Congress adopted, and then which goes together with the statute that Congress adopted in the Pensacola Act, would trump any vague language in the.
Well, we're reviewing FERC's.
The city of Miami is correct. The project boundary does not limit the scope of Article 5. That seems pretty clear.
My reading of what they're saying there is if you put the Pensacola Act aside and Pensacola Act only applies to this one project, that FERC's position is they can require that project boundary be expanded by looking at Article 5. Now that may or may not be an option for FERC before the Pensacola Act. One of the arguments that we were making is that was not an option for FERC before the Pensacola Act. So we understand why FERC would want more power, to have more power than we have. But by enacting the Pensacola Act, Congress resolved this disagreement between us and the city. FERC apparently, if it sticks to one reading of that sentence, for other projects, might believe that it can require licensees and other projects to acquire additional land and bring that into within the project boundary, which would give meaning to that sentence in the letter. But with regard to our project, that dispute, which is the line of dispute within the FERC community, is off the table for our project only because of the Pensacola Act, which I would submit is clear.
Fiscal year 2020. You asked us, I think, why did Congress pick out the city of Miami and this one project to say FERC hands off? And I'd like to know who proposed this. Was it the Corps of Engineers?
I mean, I think as far as the public record was Senator Hidlock, I think the reason that it was done is because what the city was asking for in this case would be absolutely catastrophic to this very big project. It would impose $100 million liability, which we pass on to mostly low-income ratepayers in northeast Oklahoma. Congress was understandably incredibly concerned about forcing these often low-income ratepayers to shoulder $100 million obligation for a problem, if there is a problem, which there is, which is entirely the creation of the Corps. The Corps has to manage.
The question is what will it cost to buy these? And after all, the city of Miami is losing a fortune too. That's its flooding. So the question is what the negotiations would lead to. You can't assume what the total cost would be.
Well, Your Honor, there are current lawsuits by the city of Miami against GRDA in the state court, and that can be priced there. But I was asked by Henderson, why would Congress do this? What the city was asking was to bypass all of the litigation that they would need to do in state court to prove up the actual damage, and to ask FERC to shoulder this entire giant acreage, put it on us for a problem that, if there is a problem, the Corps creates. The Corps is going to manage the entire Arkansas River system. There's tons of different projects on there. And if there's some problem that's going on downstream of the dam, the Corps tells us you can't release from the project. Their theory is that causes backup into the city. But the Corps is concerned about a lot more than the city. The Corps is concerned about the entire Arkansas River project. And so Congress will be very concerned about a proceeding brought by the city that would essentially impose on often low-income ratepayers in northeast Oklahoma the burden to pay for measures that could be being done by the Corps to benefit many projects down in many areas downstream of the dam, which as far as the Corps appears to believe that if to different measures, there will be a lot more flooding. There will be a lot more city of Miami situation.
Questions that the city would have to address with proof, and that if the proceeding, the license violation proceeding went on in its merits, could be defended on grounds of no, the authority is not the cause, or no, this is not the authority's responsibility, or responsibility. I mean, we're at a threshold point where the claim is that the authority is running its business in a way that causes huge harm to the residents of the city, and we've also told millions of dollars there, and that there's no redress. That the license says if you're going to, cause this, you need to get the land rights, and they haven't even been able to get FERC's view.
Well, that was certainly the state of play in 2019, and those arguments were there. Congress looked at it, and they said, if we allow this proceeding to go forward, and the city's argument prevail, you could have this catastrophic effect on ratepayers in northeast Oklahoma. So they took it off the table.
Is there there's no legislative history study about congressional concern about ratepayers in northeast?
No. Yeah, but I will also say for redress, the city is currently suing us in Oklahoma State Court for tens of millions of dollars. So
if they get redress, presumably they can be stopped from double recovery or anything like that, and they just want to be made whole.
That's right, Your Honor. And our position is that Congress closed the door to the extent it was ever open on them getting this redress through FERC. So they do have another door, which they are currently walked through, and they're chasing in the middle of the tunnel. So Congress has closed the FERC door on these flooding concerns, but the courthouse door in Oklahoma remains open to them, and they're currently exercising that option. I don't know if they're going.
Thank you. I don't think this is applicant Miller is going to take 2 minutes.
Two different pronunciations today. Is it Gossett or Gossett?
Thank you, Your Honor. I'll be brief. A couple of comments points. On the preservation of our argument about referring this to licensing, it's been explained in the reply brief. The commission in the staff order never mentioned referring to relicensing, so therefore we didn't raise it in a hearing petition. It was a new ground in the hearing order. There's no obligation to go back to FERC again on a point when they don't change around. On the Corps of Engineers, the Corps is fundamentally irrelevant to this proceeding. GRDA's obligations are from the project, including when it is operating the project under the control of the Corps. I mean, it's in fact no different from when it is operating the project under the control of the rule curve order in the FERC license. In each instance, It is the GRDA's employees who are at the dam, who are opening and closing the sluice, or whatever they're called on this kind of dam, and letting water through. GRDA took the license, understanding that it had obligations under it.
Even if they were not responsible for increasing the water over the top of the dam and flooding.
The water raises because of a storm or something,
Yes.
and then they are. The question becomes how much water is let through the dam downstream, which is a balancing act, which is why there's government regulation involved. But the point is that those are issues that are GRDA's responsibility with its regulators and shouldn't be borne by the city of Miami in particular as compared to all relevant parties.
What about his argument with respect to the statute?
That was my next point, so sure. I mean, I think on B3A, I think the court understood the problems with that. It's licensing jurisdiction, it's tied to the project boundary. On B3B, I think Judge Pillard put it better than I could. It's part of the project is not a term that defines a licensee's obligations with downstream rights, et cetera. And even beyond that,
Which language reference to the definition of project elsewhere in the statute?
Including in Article 5.
including Article 5. Article 5 talks about obligations of a licensee for operations of the project. It doesn't say that that's part of the project, and they have no authority specifically on that. One last point, if you don't mind, Your Honor. On the state court litigation, that is, of course, ongoing, as they said. But as I understand it, most of the litigation ongoing is still about one specific 2007 flood, 2007. It's a long, drawn-out process. The reason to get here, the core involved is to try to resolve this question on a broader perspective basis, addressing all aspects of the issue rather than through
To get more involved?
sorry. I'm sorry. I meant the commission. I did not. Thank you very much, Your Honor. I must say it's a thrill to be back in person rather than on Zoom. Thank you.
Stand, please. This honorable court is now adjourned until Friday, December 10th at 9:30 a.m.